Look at this split screen. On the left is an English common law contract, exhaustive, dense, and predicting every possible future scenario. On the right is an Arabic civil code document. It is formally structured and relies on a broader, codified system of general principles. Legal English is a highly specialized systemic language. The words used here operate as terms of art, precise verbal instruments forged over centuries of the common law tradition. Because these documents originate from entirely different legal philosophies, a direct word-for-word translation between English and Arabic often fails. A word in a common law system carries structural assumptions that simply do not exist in civil law. To master legal English, you must abandon rote memorization. Instead, you need to map these terms to the actual chronological life cycle of a legal dispute. This chart shows the architectural map we will use for this lecture, the case lifecycle timeline. We can divide any lawsuit into 3 distinct stages. For each stage, we will define the core terminology in English, explain its exact conceptual meaning in both English and Arabic, and demonstrate how it operates within a practical sentence. By understanding the operational context of a word, you move past literal translation and achieve true translation fidelity between common law and civil law systems. We start our timeline here at Phase 1, the dispute. This is the exact moment an obligation is broken and the legal conflict begins. This brings us to our first foundational terms, contract and breach of contract. A contract, or oct, is a legally binding agreement between parties. A breach, or ikhlal, occurs when one of those parties fails to fulfill their specific obligations under that agreement. Here is how it operates in practice. The company was sued for breach of contract after failing to deliver the goods. A direct consequence of a breach often involves our next term, void. To void a contract means to declare it legally invalid or without legal effect. In Arabic, this translates to batil for the adjective, or yubtil as the verb. Applied in a sentence, the buyer decided to void the contract due to defects in the product. Not all legal disputes arise from formal agreements. When a conflict stems from a civil wrong rather than a contract, we enter the realm of a tort. A tort is an act or omission causing someone to suffer loss or harm, resulting in legal liability. In Arabic, this maps to al-fa'l al-dar, or al-mas'uliyya al-taqsiriyya. In practice, negligence is the most common type of tort. Mastering these genesis terms allow you to accurately classify the root mechanics of a civil action. You identify exactly what kind of conflict you are dealing with long before it ever reaches a courtroom. Once a dispute cannot be resolved privately, it formally enters the court system. This is Phase 2, litigation. Look at this courtroom schematic. The spatial arrangement reflects the adversarial nature of the system. On one side, we have the plaintiff, also known as the claimant. The plaintiff, or al-muddai, is the party who formally initiates the lawsuit before the court. For example, the burden of proof lies on the plaintiff. They brought the claim, so they must prove it. Across from them sits the opposing adversarial party, the defendant. The defendant is the person or entity being sued or accused. In Arabic civil law, this is al-mutta alayh, and in criminal proceedings, al-muttaham. The operational sentence here is a cornerstone of the system. The defendant is innocent until proven guilty. Before these two parties can argue their case, we must establish the geographical and legal authority of the court itself. This is jurisdiction. Jurisdiction is the official power required to make legal decisions and judgments. In Arabic, it translates to al-ikhtisas al-qada'i or al-wilaya. If a court lacks this power, you might state, this case falls outside the jurisdiction of the local court. Misidentifying the adversarial parties, or misunderstanding the strict boundaries of jurisdiction, can invalidate a legal filing on day 1. Assuming the court has proper jurisdiction, the litigation proceeds to our final stage, Phase 3, the trial and verdict. The material that drives the trial forward is evidence. Evidence, or dalil, constitutes the available body of facts or information indicating whether a belief or proposition is true. It is the proof required to validate a claim. In context, the lawyer presented new evidence to the court. Once all evidence is weighed, the trial reaches its ultimate outcome, the verdict. A verdict is a formal decision on a disputed issue in a civil or criminal case. Depending on the exact context, this translates to hukm al-muhalafin or al-qarar. For example, the jury reached a guilty verdict after 2 hours of deliberation. Within criminal trials, a specific and vital type of verdict is to acquit or grant an acquittal. To acquit someone is to free them from a criminal charge by a formal verdict of not guilty. In Arabic, the verb is yubare, and the noun is bara. Applied in a sentence, the judge will acquit the defendant due to a lack of evidence. The mechanics of the dispute are now complete. The presentation of evidence directly dictates the verdict, bringing the chronological progression of the case to its formal close. Look at the complete case lifecycle timeline. The terms we cover do not exist in a vacuum. They populate a sequential journey. A breach of contract creates a plaintiff, who establishes jurisdiction, presents evidence against a defendant, and secures a binding verdict. By understanding these terms within their operational life cycle, legal English ceases to be a disconnected list of difficult vocabulary. It reveals itself as a logical, predictable system. But mastering English legal terminology requires understanding one more historical layer that permeates the common law system: Latin. Phrases like res ipsa loquitur, the phrase pro bono, and bona fide are heavily utilized in modern English law. In an upcoming module, we will explore Latin as the underlying source code of these modern legal frameworks. To reinforce this foundational layer of legal English, review the detailed dual language definitions provided in the video description below.